The next case to come in front of us is Luss versus McKenzie. I'm not sure if it's Luss or Luce, so I apologize.
Luss.
Luss, okay, good. You both will have 15 minutes to present your arguments, and you may reserve up to 5 minutes. Thank you.
If it please the court, my name is Jamie Lynn Poe, and I am counsel for the appellants Michelle Luss. I would like to reserve 3 minutes for rebuttal. The issue before the court is whether the trial court failed to comply with Civil Rule 65.1 and Rule 59 when it vacated the October 24th, 2013 order and ordered a new trial. And the answer to that question is yes, for 2 reasons. The objections filed by Mr. McKenzie under Civil Rule 65.1 were not the appropriate vehicle for his claim for relief, and the trial court's order for the new trial was both untimely and failed to state the grounds for its order with specificity as required by Civil Rule 59. Civil Rule 65.1 was created specifically to control proceedings with regard to civil protection orders, and it contains provisions unique to those proceedings. The judge is able to immediately review the magistrate's decision from the full hearing and either grant, deny, or modify that order, and once signed and filed, that becomes a final appealable order. Objections are allowed under this rule, but they're limited to 3 specific areas: either an error of law or defect evident on the face of the order, the argument that credible evidence of the record is insufficient to support the grant or denial of the protection order, or that the magistrate had used his or her discretion in either including or omitting specific terms in the protective order. Mr. McKenzie's objections are based solely upon the assertion the trial court failed to provide him notice of the trial date. That objection does not fall within any of those 3 provisions, and so the objections were not the appropriate method for bringing his claim. Even if the trial court recharacterized those objections as a motion for relief from judgment under 60B, Mr. McKenzie's argument still fails as he doesn't meet the requirements of the GTE test. The facts known on the record reflects that Mr. McKenzie was served by the Cuyahoga County Sheriff with Ms. Luss's petition for the DVCPO. Mr. McKenzie appeared at the full hearing, which was initially scheduled in September of 2013. He requested a continuance. That continuance was granted. The trial court docketed a new hearing date and time, and notice was sent to the address of record for the parties.
Could I stop you just for a minute?
Yes.
I started thinking about something. Did we show cause you on this in regard to final appealable order?
Yes, you did.
Okay. Because I was looking here and I don't seem to see that in the record, but I know we do have a comment in regard to it. So, because I'm trying to clear up what exactly happened, and like you said, it's a little unusual. So the domestic violence CPO was granted.
Correct.
And then the court sent it back for a new hearing.
Correct.
But, so it really didn't vacate the order.
It did.
Well, how do you do, okay, go ahead. I guess I thought it was continued during the pendency too.
The October 24th, the final order was vacated. The ex parte order was put back in effect.
During the pendency?
During the pendency. And a new trial was ordered.
But ex parte, could that be put back in effect for all that time?
That would be a question.
Because it's been several months now, right?
From the ex parte, I think it's been a year and a half.
Wow.
Yes. So
I'm sorry for getting
no,
you on the train
that's
of thought. It's just that if I didn't, I'm a lot older than you, so if I didn't ask it while I was thinking about it, I would have forgotten.
So Mr. McKenzie did not appear for the continued trial date. Miss Luss did. The court took testimony and evidence, and on October 24th, 2013, it issued an order granting Ms. Luss's petition for the DVCPO. It was signed by the court and filed, and therefore became a final appealable order at that point. The DVCPO, that decision was again sent to the party's address of record, and Mr. McKenzie timely filed objections to that decision. Again, his sole objection is that the trial court failed to provide him with notice of the trial date, but there's no evidence of the record to support his position. The objection is based solely upon a statement by counsel. There's no affidavit to support the argument that Mr. McKenzie wasn't served. There's no evidence, no testimony. The trial court's docket shows no mailing was returned to the court. Mr. McKenzie was able to timely file his objections, and in fact, the very address he's complaining about remains his address of record to this day.
He indicates, though, that he told the court what the address was.
And while it may be a concern that a pro se litigant provides an address to the magistrate during a full hearing, the address wasn't updated with the court. That's not really the issue in the case. In the Ohio Valley Radiation decision, the Ohio Supreme Court noted that no statute or rule provides for notice of a trial date by a court, and absent a local rule, the civil rules are silent as to notice by a trial court of a trial date. The court found that while Ohio courts have traditionally held that where some form of notice of trial is required to satisfy due process, and entry of the date of the trial on the court's docket constitutes reasonable constructive notice of that fact. Medina has no local rule that requires a trial court to send notice. There's no case law, statute, or rule to support Mr. McKenzie's argument that he was entitled to some sort of additional notice. The record shows the date was docketed with the trial court, and that was enough. He had an affirmative duty to keep himself apprised of what was going on, and he failed to appear for a scheduled, docketed trial date. Mr. McKenzie can't show he falls within...
It just seems like a scary proposition, though, doesn't it? Would you as counsel want to keep track of your 150 clients just by checking the docket every day instead of getting notice? I mean, would that be a viable ruling from this court?
While I understand that that is a concern, he didn't file a change of address with the court. He did not. So he said it to the magistrate, but he never actually filed a change of address with the court. And courts speak through their dockets. At any point in time, someone could come in and say, I had a new address, or it wasn't sent to somewhere, and we would essentially be reopening litigation. In my head,
within the court's discretion, isn't it to determine that under the circumstances of those facts that justice would permit giving the person another chance? But your issue is that it should not have been a new trial because there was no motion for a new trial or new hearing.
Correct. And even the vacating of the order under a 60B, for example, you not only have to show he fits within, Mr. McKenzie would fit within one of the 60B 1 through 5 provisions, which is I think what you were referring to, but he also has to show that he had a meritorious defense. And again, there's nothing in the record to indicate that he even asserted an argument that he had a meritorious defense to fit the GTE test. We will concede that if the objections are considered a 60B motion, that they were timely filed. So, for the reason that I just stated, because we would argue he can't fit within, provision 60B 1 through 5, but also that he hasn't shown he had a meritorious defense. He can't reach the GTE test, and so it would have been it was abuse of growth. It was an abuse of discretion to vacate the October 24th order and order a new trial. Then, absent a motion by either party, trial courts are permitted to vacate their orders based only on clerical errors. And courts can vacate for substantive reasons, but there has to be a motion before the court. In this case, there was no motion. And so the July 17th order that vacated would have had to rely on clerical error. It didn't. And so again, we would argue the court abused its discretion. And finally, the trial court failed to comply with Rule 59 when it granted the new trial. The October 24th, 2013 order was a final appealable order under 3113.31, 65.1, and 250502. And Civil Rule 59 allows the court to sua sponte order a new trial within 28 days of that date. The new trial wasn't ordered until July 17th. In addition, 59 requires that the court state with specificity the grounds for the new trial, and the July 17th entry was silent as to why it granted the new trial. Do you have any questions about the final appealable order issue?
I don't believe so. You are in your 5 minutes if you want to say that for rebuttal.
I would, thank you.
Fundamental, Attorney Ray Johns on behalf of the appellee. Fundamental fairness is always hopefully something that we deal with, and due process is mentioned way back when the country was first being founded. And I think due process means that you have an opportunity to appear and defend. I think the court also, by the way, indicated we should be checking the docket. This docket is not public at all. You cannot access the domestic relations docket, and I think the court would take judicial notice of that. This is by rule. The docket here is not available for the public.
You just said something, you said opportunity to appear. What about the fact that his address of record is where it was sent? He hasn't changed his address of record.
The interesting thing is, I guess you can say that ignorance is not an excuse for anything, but there should also be some sort of warning that you are going to be in jeopardy unless you file a change of address form. If you take a look at what is in this file, which is the ex parte order for the CPO, you will find nothing in there indicating that you are to notify the court of any changes of address. That's the initial order that comes out in the ex parte.
Well, didn't he have an attorney then?
No, he did not. So he appears on the 24th hearing, and again, I don't know where he was served by the Cuyahoga County Sheriff, but in any event, it's very clear, and it's in the record here at page 2 of the September 24th hearing. The court is inquiring about service. The court, thank you. Please be seated. Mr. McKenzie, it says here that you received service by the Cuyahoga County Sheriff on September 16, 2013. Mr. McKenzie, that's correct. The court, what is your address? What's your mailing address? Mr. McKenzie, 328 Springbrook Drive, Medina, Ohio. The court, okay. Then the court goes on to indicate, yes, I'm going to give you a chance to get an attorney, grant your motion continuances, want any more continuances, no problem.
Excuse me, counsel, this is at before the magistrate?
Yes, Judge.
Okay, thank you.
Then again, that's the initial September 24th hearing. So.
And then he did get an attorney then?
At a later point of time.
Well, I'm just going by the appellee's, the appellant's reply brief. There's no evidence Mr. McKenzie or counsel undertook measures to determine the new hearing date.
That is correct.
So did an attorney enter an appearance?
No. The only appearance that's been entered is when he came to see me, we checked the docket, found out there was a decision, and we were within objection time. And so I filed objections at that point in time. Because he comes in and basically says, Ray, I don't know what's going on. And we check the docket, we find out there's been a decision. And again, I disagree with the other attorney, by the way. The initial decision that we had that came out in the second hearing is not a final appealable order. It is a matter which can be objected to, and in fact, as indicated, timely objections that were in fact filed with reference to this. Which she quotes at 65.1, again, I really don't think applies here. It's what the modification is under 65.1C is the modification is I'm sending it back to you, magistrate, and I want you to rehear this. I want you to listen to the evidence that Mr. McKenzie could have brought forth if in fact he had been notified of the hearing.
But the trial court specifically vacated decision, correct?
Yes. I would say it modified the decision by eliminating the decision and indicating you're going to have a hearing.
That's torture.
It is torture, but I mean, these are, what we have here really are hyper-technical tortures of the civil rules in order to achieve a result which results in lack of due process, which again is a fundamental issue of fairness that we have. And you have another thing here too. You know, this objection has to be ruled upon with abuse of discretion standard. And you've got to find basically that the trial court is acting malevolently in entering this decision by saying no due process. I mean, the court doesn't mention the word due process, but that really is what the argument is. It's a due process argument. And you're not going to find any evil intent or abuse of discretion by this court going, my magistrate asked you what your mailing address was, and I have a feeling that the other attorney will admit that she didn't find out about the hearing date by looking at the docket. I have a feeling that she received a mailing notice, just like the petitioner in this particular did. So again, as the court mentioned, checking all the cases that you have pending on a daily basis on a docket becomes an insane situation where you can't practice law anymore. You're just checking dockets, or you're devoting one staff member to doing that. Again, it was an interim order. It is not a 60B because it is not a final appeal order. It is just as any other objection. And, you know, the words, I guess, on behalf of my client, I think he certainly acted with detrimental reliance upon the fact that the court would, in fact, after inquiring as to what his mailing address was, because there must have been some reason why the court was asking, you know, his mailing address. He would have expected to get a notice of the hearing, could have turned same over to his attorney, and been appropriately represented. Again, we would ask that the court in fundamental fairness, again, as noted in the brief, the fundamental idea is that the rules will affect some semblance of fairness. And there is no fairness unless the trial court's decision stands in this particular matter. Thank you, judges.
The issue of whether or not this is a final appealable order under 65.1G, it states very clearly that when an order is entered by the court in accordance with section F3C of the rule, which requires the judge to look over the magistrate's decision after the full hearing and either modify, grant, or adopt or reject the order, with or without the subsequent filing of objections, the order is a final appealable order that can be appealed upon issuance of the order. 3113.3G, which is the statute controlling civil protection orders, states that an order issued under this section other than an ex parte order that grants or approves the consent agreement, modifies or terminates an order or consent agreement, that refuses to modify or terminate a protection order or consent agreement, that refuses to grant a protective order or the consent order is a final appealable order.
So are you saying that the objections were completely irrelevant, that you shouldn't file objections, or you have no authority to file objections?
You do, under 65.1, you do within those three categories, but if you don't fit within one of the three categories, it needs to be a 60B. It's a final appealable order. And with regard to the due process, again, the Ohio Valley radiation case came out in 1986, I believe. And as far as I'm aware, the court docket was not available online at that point. And this court in Highland versus Malforney ruled in that case the parties were in arbitration. The appellant moved to continue the arbitration date. That was not granted. So the person knew that arbitration was going forward. The arbitration decision was filed with the court. All the parties conceded that they were never sent notice that that arbitration decision was filed with the court, at which point 30 days began. The appellant in that case argued that because they weren't sent notice that there was a due process issue. And this court specifically found, again, that you have a duty to keep yourself apprised of what's going on in your case. Mr. Mr. McKenzie had the opportunity to call into the docket, or to call into court and find out. He knew the date was continued. Even if he gave the court his address, even if he changed his address with the court was still not required, under the Supreme Court decision, to send notice of the trial date. There's no due process violation in this case, and so again, we would argue that the July 17th, 2014 decision by the trial court to vacate the October 24th, 2013 order and order a new trial was an abuse of discretion. Thank you.
Thank you. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we will post on the Ohio Supreme Court website and our own website. Thank you very much.
Thank you.